Hi, good evening, everybody. I hope you can hear me. My name is Claudia Testerine Campbell, and I'm just checking if you can hear me. I am the president of the Daughters of Sheba Foundation. Thank you for joining us. And we have a very special evening today, tonight. So I would invite you to take a minute and share the video, the live, as we have special guests, and we're talking about a very important topic. Our conversation this evening is about estate planning, and our focus, as you all know, is on women. So our conversation tonight is mainly targeted to women, but it is not only for women, and especially those women over 40 years old. Estate planning is a crucial but often overlooked aspect of financial empowerment, particularly for women navigating midlife transitions. Studies that I've read show that many women, especially those over 40, have not yet secured a solid estate plan, leaving their assets and families vulnerable. We hope to change that tonight with our conversation with Holly and Hije. Turn this down with Holly and Hije. So without any further ado, I am going to get us started and get us rolling. Thank you for joining us. The name has changed, but the conversations remain the same. It's now a woman's perspective. The Daughters of Sheba Foundation will continue its tradition. Nothing will take us off track from the woman's perspective. Join us each month. Again, thank you for joining us. My name is Claudia Testerine Campbell, and I am co-hosting tonight with Colleen, my dearest compatriot and comrade in crime and partner in crime and partner in all sorts of mischief. So Colleen is with me tonight, and we have two very special guests with us tonight, and I'm going to bring them in. Attorney Holly Gerdes and Hije Hoon. I know I've massacred your names. Please forgive me. I will get it once you repeat it. And but I maybe because I'm so thrilled to have you here. You know, I made a connect with someone, and then the next thing I know, I had Holly on the phone. So I am just so pleased. Holly is a premier trial and asset protection attorney in the United States, and I could not be any more thrilled to have her here along with her colleague Hije, taking us through this process tonight. Just a little background, due to Holly's experience and expertise, she has extensive management and leadership experience. Her highly successful legal career in the state governments also has enabled her to maintain close ties with both local, state legislators, and she's just a top-notch lawyer. There is no other way of saying that. And not to take anything away from Hije, every aspect of estate planning, wills, trust, business succession, and asset protection, that's up his alley. So I'm not going to take any more time tonight because we don't have them for hours, the amount of hours that it would take for us to talk about all aspects of estate planning. I'm just going to hand over to Holly and Hije, and then I have a long list of questions that people have sent in that I will put to you guys once you have made your presentation. So we will stay in the background and listen and learn.
Well, thank you, Claudette and Colleen. Can you see my screen?
It's there.
Yes.
Oh, wonderful. Yes. Okay. So thank you everyone for attending this evening and for anyone that will watch this video after this night's event. And Daughters of Sheba, I think it's amazing, wonderful thing that you're doing for your community and for women all over the world. And it's just amazing to have people that their focus is trying to make their community better and to give back. And so when Daughters of Sheba had reached out to us on trying to see if we could educate women in general, because really most of the time when it comes to estate planning, probate, establishing trust for families, it's generally the women that come in. It's generally the women that are more active and more responsible. And that's just our nature. We want to protect our family and we want to do everything we can to have peace of mind that our family and our assets are protected. And there are a lot more at risk for women too, because we generally outlive men. So this is relevant that generally we're the ones dealing with the death of our husbands first. And then we have to deal with probate and other things that happen when the first spouse dies. And so we're going to talk about just in general about how to protect your family, everything that you own. And some of you or many of you may own businesses. And so I want to also introduce attorney Hee Jae-yoon. He is one of our lead attorneys in our office. We have offices and license in over 25 states. So we are in very high demand because we only do this and we specialize it and we're the best at what we do. Now, I'm going to put up this QR code that you can take a picture of, and that will lead you to our website, our locations. You can watch other webinars. Attorney Hee Jae-yoon does all our webinars every Wednesday at 2 p.m. And then schedule a one-on-one complimentary consultation for those that are from the Sheba of Daughters or that attended one of these. So when you do schedule a complimentary consultation, probably by Zoom, you have to indicate how you heard about us. So take a picture. We'll put it at the end. And if there's time for Q&A, I'm not for sure if we're doing that, but we'll put this QR code again at the end. Now, what is our schedule this evening? We're going to first discover the 3 steps to plan and protect your assets. Then we're going to talk about how do you actually do it? What are the different options and estate plannings that people do to protect their family, their assets, and some of you also your business? Now let's go over the topics that we're going to cover today. First, we're going to talk about how do you protect everything that you own from certain predators like creditors, lawsuits, divorces, your husband's remarriages, probate court, long-term care costs, Medicaid, sometimes taxes. And unfortunately, we have to sometimes protect ourselves from our own family members. And then we're going to learn what this trust is about, what are the different types of trust, how do you create it, and why do you need it? Do you need a will? Who needs a will? Who needs a trust? For most people, if you don't have a trust, you have to learn to navigate probate court. Probate court has exclusive jurisdiction over people's assets when they die, or become incompetent unless you prepare the necessary legal documents to bypass probate. We'll talk about how long it takes, how much it costs, and how you avoid it. Most of us have children. So how are we going to pass our assets to our children where it's not wiped out within their lifetime? You worked your whole life to own a home and other assets, and then when you die and you give it to your children, it's gone. They spend it, they have financial problems, they have creditors, sometimes they get divorced, and it's just gone, everything that you work for. So we're going to talk about how do you protect the assets even after your death for your bloodline. We're going to briefly talk about long-term care costs because it is the number one devastator for female seniors. Not males, female seniors. We're going to talk about why it's a financial devastator, how Medicaid relates to the long-term care crisis, and how do you protect assets from long-term care costs and even possibly Medicaid. Now, you also need documents when you're alive, not just at your death, to deal with incompetency. The default tonight for everything is probate court, including if you or your spouse become incompetent. How do you ensure that the trusted people, the people you trust, manage your assets, make your medical decisions, and life support, life and death issues when you're incompetent? If you don't prepare the necessary documents, the only option is probate court and predators, people that will take advantage of you when you're the most vulnerable. Some of you, or you know people that have disabled children, and they've done no planning. Most, if not people that have disabled children, do not plan to protect their children after their death. It is mind-boggling. I don't understand how people with disabled children, and they become adults, they don't plan to protect the assets and the children from predators. Because that's what happens when you leave children, let alone minor children, but disabled children, to fend for themselves, it never turns out well. It's an absolute disaster, and it is a sad, sad story. Mm-hmm. And then we'll briefly talk about, if we have time, the federal estate tax. It only affects about 1% of the population, but let's have fun and pretend we won the lottery and then see how much you're going to owe the federal government. And again, I mentioned some of you have LLCs or corporations that you put your real estate. Maybe you're an entrepreneur and you have a business. How do you pass that to your spouse and children? Because if you don't have the right documents, it ends up being turned over to probate court. All right. It's a lot we're going to talk about tonight. But when you touch upon all these different subjects, you should be setting up a following consultation to narrow it down to your family, your wishes, your wants and concerns, so that the attorney can make the right recommendations for you. Now, what are the 3 fundamental steps to plan and protect your home and life savings? Number 1, you got to know what the rules are in the United States and also in the state that you reside in. And the rules are not what your friends say, your neighbors say, your relative says, because many people give you bad advice with good intentions because they don't know what they're talking about. But they assume what other people told them is what the law is. And in reality, the people that give good advice or bad advice with good intentions can be financially devastating for people that rely on that and never found out the right rules and the right law pertaining to their assets and their family and their businesses and the state that they live in. Now, you also need to know who your predators are, who can wipe out your assets during your lifetime and even after your death from your spouse to your children and your grandchildren. And so when you do your estate planning, you may want to think about, I want to make sure that my assets are protected against these various different types of predators. And then finally, you got to know what your options are. How do people protect their assets from these various different types of predators based on the laws in the United States and in the state that you reside in? So let's begin with the rules. Estate planning, by the way, is not just about death. A lot of it happens during your life, and probate court steps into the picture. So we're going to talk about two simple rules, one when you're alive and the rules that apply after your death. Now, what happens if your spouse has dementia or stroke? Many of us still have parents alive. And when they become incompetent or have a long-term care disability or they pass away, guess what? We're the ones that have to pick up the pieces and do everything. So you need to understand these rules not only for yourself, but also for your parents. Now, when you're healthy and competent, you control everything. But if you have dementia, stroke, Alzheimer's, any kind of mental cognitive disability, when you no longer know what's going on, people can take advantage of you. Mm-hmm. Sharon Stone had a brain tumor, stroke, and for a few years, all the people around her that were supposedly helping her stole several $1 million while she was mentally incompetent. She didn't know what was going on. She was struggling. Now, she recovered, but she had virtually lost all her money to people that took advantage of her in that situation. But she didn't have the right documents to put in place people that she trusted to manage your assets in the event that you have any cognitive disability, temporary or permanent. And so either predators are going to take over your money and steal it, or you've got the probate court. And that's expensive too. They won't steal your money, but it's expensive. And probate court can take over you and your assets for the rest of your life. I'm going to talk about a couple celebrities, but if you don't have the trust and the financial power of attorney, and you appoint the person that you trust to manage your assets, if that ever happens to you, then it's probate court or you've got predators ready to steal your assets. Now, to avoid that, you have to have the right power of attorney. There's different versions, by the way. Even if you have the right one, guess what? You got to make sure that it's sufficient and complete and gives all the powers necessary for the person you trust to manage your assets for your care. Now, if you're going to give them all the powers they need, guess what you also need to do? Make sure you're protected so nobody takes advantage of you, even your own agent. Now, can you do that by yourself? Probably not. If you want to do this right, you should seek legal advice, because this only has to happen once when this doesn't go wrong. This only has to happen once when someone steals your assets using this power of attorney. So make sure when it comes to these documents, because you're still alive for I don't know how many years, but you need to have your assets protected. Same thing with the healthcare directive. Who's going to make your life and death decision if you can't make it? You're in an emergency room and you didn't appoint anybody, or you don't have the healthcare directive. Then nobody makes a decision except complete strangers who could care less whether you die or whether you suffer. They don't know you. And you also need to tell your family what you want. Because if you don't tell your family under what conditions and circumstances you want life support, and when you don't, and for how long, then they make the decisions for you. And it's not always the decision you would have made for yourself. You may suffer too long. You may die too early. Your family's going to fight over who's going to make the decision. Your family's going to fight over what decision to make. All traumatic and chaotic when these are simple documents that you can customize to make sure that this works and that your family knows what you want. You appoint the trusted people, and that there's nobody fighting and agonizing over the decisions that you should have made and told your family. Now, Jay Leno didn't have a power of attorney, didn't have a trust. His wife has dementia, and he had to go to probate court to try to get appointed as a conservator over his wife's assets. What was a very private affair became completely public of what was going on with his wife, what the assets were, and now he has to go back to court every single year to give a full accounting of what the assets are and how he spent it for his wife. Very expensive and time consuming. What about Wendy Williams?
Yeah.
Yeah. She had no power of attorney, no trust, and now complete strangers are her guardian, dictating her daily decisions and having complete control over her assets. And it wasn't a family member that alerted social services that started this whole process. It was Wells Fargo Bank, because people were starting to take advantage of her financially with their bank account. And that started that process. And now, if you ever watched her documentary she did, by the way, they didn't pay her that much, which is exploitation again. That was before the court got involved. Also, she claims she's broke. Well, you understand why she is, right? Because she doesn't have control over her assets anymore.
Wow.
None of her family has any say. None of her family has any access to her money. Nothing, nada.
Wow.
In her mind, rightfully so, she is broke. She doesn't get to decide what happens to her money, which is significant. And you
Ellie,
also
can I ask a question here? Why is it that celebrities and people who you think would know don't have the proper power of attorney and all that?
Exactly.
having money doesn't make you any smarter.
True.
They know with respect to their profession. Having money doesn't necessarily give you access to the right people. Having money doesn't mean that they seek out information related to this information. So no matter how much money you have, we're all the same in the end. We die. We're all dying. We all get sick. Majority of people in the United States still lack knowledge about this area of law. We have a tendency to think that we're going to live another day and another day and another day, and it just goes on, and we procrastinate. Also, there's not enough estate planning lawyers. So to fill in the gap, we have these do-it-yourself stuff, which, unfortunately, and by necessity, it exists. But all it does is just bring more business to probate, because the do-it-yourself trust, they all go to probate because people sign 30-page documents that they don't really know.
Nothing to read.
They don't fund it. They don't read it. A whole host of problems. And it does make probate much more expensive, but it does end up in probate. Our probate practice hasn't increased because of people dying with no will or just a will. It keeps increasing because of these do-it-yourself trusts that people do. And sometimes even lawyers don't do it right because they just want to provide something cheap. Clients don't want to pay much, even though the cost of probate is higher. There's no comparison in cost. The trust is, even when you do it right, is minuscule compared to the cost and time of probate.
So what is the best thing to do to avoid probate?
Oh, we're going to talk about that.
Okay.
That's the next part now. Attorney Hije is going to talk about the rules after you die and what you need to do to bypass that.
Thank you, Attorney Holly. Attorney Holly, by the way, the slides haven't been moving.
Oh, really?
No. Okay.
Oh.
So what are the rules after your death? How many of you guys know where your assets will end up?
How many of us
Most,
know our assets? One, sorry.
how many of you guys
Will
know where your
end up.
assets will end up?
Oh, we
Most
don't.
people are in what we call the no will category. That means they have no will, no trust. They haven't done anything to prepare. So if you don't have any of those documents, this is the situation. And this is what happens after death. The probate court steps in, takes control over the assets, and you can't do anything with those assets as a spouse or a child. If you touch the assets, the courts can actually require that you bring every instance you touch the assets back to court, because you're not authorized to touch the assets. And those assets are frozen with the probate court throughout this process. And this process will take at least 1 to 2 years minimum and cost anywhere from 5 to 20% of the value of assets going to probate. That's based on an AARP study a few years ago. Now, that 1 to 2 years and the 5 to 20% is assuming that it's a smooth probate and people aren't fighting over the assets. If anyone's fighting over the assets, it will take longer than 1 to 2 years, cost way more than the 5 to 20%. And if you're going through this process, everything becomes public information. There's zero privacy. And since you didn't do anything to prepare, you have absolutely no control over who's getting your assets. The surviving spouse, they may only get a half or a third of the assets. If you own assets in more than one state, you actually have to go through this process in every single state you own assets.
Wow. So you pay probate fees in every single state?
Yes.
Oh dear.
Wow.
And if you have minor children, those assets are stuck with the probate court until that child turns 18. And keep in mind, none of those assets can be used to help raise your child. It's stuck
Somebody's
with the probate
asking
court.
a comment, is asking a question, and sorry, I will from time to time just bring this up. She's saying she has a will, but she's now wondering if that's enough.
We will get to that next part on the next.
Okay.
Okay. And so if you have minor children, none of those assets can be touched. It's held by that court until that child turns 18. And they're handed one lump sum with no instructions, no protection. This is the process most people find themselves in. And this is because they don't do anything to prepare. Now, going to that question, they're asking if you have a will, is it enough? Well, unfortunately, the process itself doesn't change. You have to go through the exact same process if you have a will. The only difference is you file your will with the probate court. Whereas if you don't have a will, you don't file that, right? Everything else is the same.
So it will still take the same amount of time, except for the time. Oh,
Same time, same costs. It's still stuck with the probate court. You may be the sole beneficiary on the will. You still can't touch those assets, not while it's stuck with probate court.
oh.
Okay. People have this misconception. They think if you have a will, it'll take care of everything.
Mm-hmm.
Well, unfortunately, that's not true. I think, Hollywood doesn't do us any favors, because, what you watch movies, TV shows, what do you normally see when they're dealing with this in the show? I mean, tell me if this sounds familiar to you. Someone dies. They're trying to deal with who gets what assets. That family attorney contacts the family and say, hey, you guys need to come into my office on this date and time. We'll have a will read. They come in, the attorney reads the will, and then the next scene is the family is going away with their assets as listed in the will, no matter how unhappy they may be. Sound familiar?
Yes.
Mm-hmm. Yes.
Pure Hollywood magic. That does not happen. I want you to tell me, how many of you guys have ever heard anyone tell you, hey, my father died, I have to go to his attorney's office because they're doing a will reading?
Nobody.
Right? So it's pure Hollywood magic. Everything stays the same. Okay? And you still technically do not have control over who your beneficiaries are.
Even if you name them in the will?
Yes, anyone can still fight.
Wow.
And keep in mind, even if someone fights and say, that asset's mine or whatever, they don't necessarily have to win. More often than not, they don't win. It usually doesn't end up going all the way through. They usually end up settling. Why? Because I told you it's going to cost more and it's going to take longer if people are fighting. Do you know where a lot of the money ends up if there's a long disputed fight?
Probate?
Attorneys pocket.
Attorneys. Yeah.
Attorneys fees go up.
So the will don't seem like it has any use much. I mean,
So it's just a recommendation. As I said, nothing changes, right?
And EJ, can I make a comment here?
Yeah.
So if you don't have anything, you at least need a will to tell the judge in probate court, because it has to go to probate, who you wish your assets to go to. You do need a will for minor children to appoint a guardian. Now, that's not over the assets. It's just who will have physical custody, who you recommend. Okay. But at least a will, if you're not going to do a trust, you at least can tell who you wish your assets to go to. But in the court system, anybody can object and challenge. I think everybody understands our court system as to litigation. We are litigation prone. Because there's no penalty for making challenges and objections and making life hell for other people. But let's talk about James Brown. He had a perfectly valid will, very, very clear. No ambiguity. Everything I own goes to nonprofit for underprivileged children and another portion to go to grandchildren for their education. Perfectly clear. But he had an ex-wife. He had a wife that was married to somebody else. So he was in the middle of annulment at death. And he had 9 children that he knew of. So who do you think challenged the will?
The ex-wife.
Even though it's perfectly clear.
children.
Yeah, all the children, ex-wife, the wife that he was married to somebody else. And they got a whole lot of his assets, despite the will saying that it was to go to a nonprofit and his grandchildren.
Wow.
So what EJ describes, whenever there's fighting, it's the people fighting over your assets that ultimately determine who's going to get what, because the cost of litigation to go to trial at the end is astronomical. So people have to decide, let's get something instead of wasting it all in fighting and giving it all the money to the attorneys. So that's what EJ means about just having a will doesn't guarantee that that's going to happen, because it's going through probate court. We have to notify everybody in the universe, did this person owe you money? Are you a relative? A number of things that have to be done that make it possible for people to come in and challenge even the will.
Wow.
Mm-hmm.
Going back to the will, everything's still public information. That includes your will, by the way. How do you think Attorney Holly knew all about what James Brown's will said? Because the newspapers reported it. Now, how did the newspapers know? They went running into the courthouse. They asked for the copy of the will. They got it, right? So everything's still public information.
That should be legal.
Court proceedings in the U.S. are generally public, and this is a court proceeding. So everything's public. That includes your will, okay? Now, to help you understand just how costly this is, I want you to go just total up everything that you own. People think, I don't have much, but then go total up everything. Your house, your business, all your assets, and then multiply that total figure by no less than 520%. That's what it's going to cost if you have to go through probate, right?
Wow.
Now, if you have debt, though, do you know what happens? If you've got any debt, all those creditors have to be paid in full first. Remember I told you the assets are frozen in probate court. Guess who gets paid first by the court? Your creditors, the attorneys, the courts, the IRS, credit card bills, and anybody else that thinks you owe them money in their lifetime, including any unpaid medical bills and your funeral costs.
That was one of the questions I had on the list from followers, that the debt that you leave behind, they wanted to know who pays that.
Your estate has to pay everything before your family receives a dime. They don't receive a penny until all these other people are paid first.
So the debt doesn't die with the person. The debt doesn't die with the person.
No, does not die with the person. So
even if it's a living trust.
even with a living trust, it doesn't die with the person, but you have more options. The
Oh,
reason why all the creditors have to be paid in full first is because once probate finishes, they can no longer collect on any debt of that person. That's why they
oh,
all have to be paid first. When you have a living trust, since you're not getting stuck in probate and their ability to maybe seize the house or whatever is not foreclosed, the beneficiaries can work something out with those creditors. Doesn't necessarily have to be paid in full right off the bat, right? Maybe they just take over the loan. They refinance or whatever, okay?
oh,
So if you want to avoid that whole process, you've got to do something more, and that's called the living trust.
oh.
That is your best option. And you will notice that the process is almost the direct opposite of probate. The court doesn't take control over your assets. They don't ever step in. You actually don't have to go through probate. So none of the assets become frozen. So it can immediately be transferred and controlled by your loved ones. Since you're not going through probate, you won't incur any of those fees.
Right.
Everything here remains private. And you have full control over who your beneficiaries are. Now,
Okay. Can I just ask you, for those of us who don't really know, what's a living trust? Just in
I guess the simplest term is you can think of it like a private contract.
like a private what?
Contract.
Okay.
Okay. You are living trust is sort of like establishing a separate sort of company or entity. So it's a contractual relationship that gets created, but it's trust would be a separate entity like a company holding assets for the benefit of whoever the beneficiaries are.
Okay.
Okay. Now, keep in mind there are many different types of trust, and they have different purposes. And depending on the type of trust you use, you can protect your assets after death or even during your life. And that depends on the type of trust you do. Okay. Now, Attorney Holly had said, not only do we have to know the laws or the rules, right? We went over the rules, but we also have to know who our predators are, right? These are the top four. The first one's the government. It's always waiting for you not to do anything. Remember? The second one is long-term care costs. It's the number one single financial devastator for a lot of senior citizens because they don't prepare properly for the astronomical long-term care costs if they need home care, if they need to go to a nursing home. The third one, unfortunately, is your family members. They can become a predator. Now, oftentimes, it's unintentional, right? Because, you don't really think about what happens after your death, right? But they may just completely drain your assets in the first 2 years. I mean, did you know most inheritance that children receive usually doesn't even last the first 5 years?
Wow.
Most of them are gone within the first 5 years because they lose it to their creditors, their lawsuits, their divorces. Right? And finally, the last one, anyone can become a predator. As Attorney Holly said, we're a very litigious society, right? A lot of business owners understand this concept. Anybody can be sued at any time for any reason. Now people think, well, there's a lot of those frivolous lawsuits, right? So what happens? And they think, you know what? It's completely meritless. I can just leave it to the courts. Unfortunately, Attorney Holly is well aware of this because she has litigation experience as well. If you do that, you're going to lose that case automatically. So you actually have to go spend your own resources, go hire your own attorney and defend yourself, even if the case seems so frivolous, right? And so anybody can become a predator. Now, let's talk about trust since you guys have asked. How do you establish that trust? Well, if you're going to establish a trust, when you are writing that document, you pretty much appoint 3 different sort of positions, or actually 2, because one of them, since you are establishing it, you will be called the grantor. That means you're the one creating that trust. right? Establishing that trust. The second type of people or position is the trustee. That's the person managing the assets you put in the trust. And the third is the beneficiary, who receives the benefits of the assets placed in this trust. Now, for most trusts that people create in their lifetime, they will be all three initially. I mean, they are the grantor setting that trust up. They will be the trustee managing all the assets that they just put in their trust. And they will take the benefit of those assets during their lifetime. For most trusts that people do. Now, just because you create that trust, it doesn't mean you're done. Because just because you signed that document, Attorney Holly had sort of referenced this earlier, just because you create the trust document doesn't mean you finish the process. This is a part that a lot of people make mistakes on. Because she had mentioned funding the trust. That means you have to integrate all your assets with the trust. Because if you don't put any asset in the trust, those assets are outside your trust, cannot be controlled by your trust, and will have to go through probate. This is, as I like to say, a Michael Jackson mistake. Are you aware he actually had a living trust, but his entire estate went through the whole probate process?
No.
That's because he didn't put a single item in his trust. Okay.
So what was the point?
Yeah.
It
Well,
doesn't.
the point is you need to set up the trust completely and correctly.
Correctly. And this is very technical. You know, a lot of people try to do it themselves, right? Attorney Holly had mentioned the do it yourself. And even with some attorneys, they don't help them do this. And so, you know, they try to do it themselves. They think it's funded properly. They usually never, ever find out that it wasn't done properly. You know who usually ends up finding out that it wasn't done properly? Their family members.
Family.
After their death, when they're having to go through probate. Right? So you have to put the assets in the trust correctly. Now, as I said, there are many different types of trust. So let's talk about 3 broad categories of trust. Now, keep in mind, these are very broad categories. There are different types of trust within these categories. But the most popular one, the one that most people do, and it's usually the foundational one, is the revocable trust that's on the left. Okay. This type of trust is a type of trust where you can revoke, amend, or terminate at any time, so long as you're alive and competent. That's the one that's on the left. For this type of trust, you will be the trustee managing everything you just put in your trust. You have complete access and control over the assets. You can make any changes to this trust at any time, so long as you're alive and competent. You don't have to go get a separate tax ID for this type of trust, and you won't be filing a separate tax return for it. The irrevocable tax avoidance trust, we haven't really gone into estate taxes, but the irrevocable tax avoidance trust is only used in the event you will actually have to owe estate taxes. Okay. But for that type of trust, you cannot be the trustee. So you're not managing anything you put in the trust. You don't have any control, use, or access to any asset you put in that trust. You cannot make any changes. You cannot terminate this type of trust.
Which one is that?
The irrevocable tax avoidance trust on the right. For this type of trust, you actually have to go get a separate tax ID and file a separate tax return for it every single year. You technically don't own the assets anymore. It's a completely separate entity from you.
And give us an example. Why would somebody do that?
Because, okay, so let's get into estate taxes a little bit. When you die, let's talk about just the federal. When you die, if you have a certain amount of assets, the federal government taxes your estate and estate tax.
Okay.
The estate tax rate is 40% of anything above the exemption, almost half.
Wow.
Okay. And the current exemption is about 13 million, meaning you're not facing that. Excuse me. Tax if you're under 13 million in assets. Excuse me. Except on January 1st, 2026, that drops to between 5 and 6 million. And so if you're above that limit, you would use these type of trust to try and minimize or avoid that estate tax. So that's why people would set one of these up. Now, the irrevocable asset protection trust that's in the middle, we like to say it's a hybrid. because it combines aspects of the irrevocable tax avoidance trust for asset protection, but combines aspects of the revocable trust where you have some control over the assets. For this type of trust, you can be one of the trustees. And in most states, you will need a co-trustee to help you manage the assets you put in here. You have control and use of the assets, you just don't have any direct access to it anymore. You can make two very limited changes to this trust. You can change who the trustee is, and you can change who the beneficiaries are. You don't need a separate tax ID, and you won't be filing a separate tax return for it. But for this type of trust, you only put in the assets that you want to preserve and protect to pass to your loved ones. Any assets that you want unlimited access to, that you want to pay your bills with, and to use however you want, live off of, you leave out of the asset protection trust and put into the revocable trust. Okay. But whatever assets are in that asset protection trust cannot be forced out of that trust to pay for your nursing home, to pay your creditors or whatnot. It's protected. So if you're going to do asset protection trust, think of it like the family vault, okay, where it's protected just for you and your family. Now, if you're just going to do a will, please keep in mind, you will have to go through probate regarding certain assets. If you're going to do a trust to avoid that probate process, make certain you integrate all your assets with the trust so that you actually can avoid that probate process. But whatever you do, review it regularly and update it as things change, because things do change. Okay, I've had people come into me who did their will 30 years ago, and since then they've had additional children. They've gotten divorced, right? That's why you have all this mess with some child running in saying, wait, you can't give all my father's assets away. I'm not in that will because he did it before I was even born. So make certain you review it regularly and update it. Tony Holly, is there a few other things you want to talk about?
Yeah, one last thing. Kobe Bryant, after he died, the wife had to go back to court to request a modification of the trust that he did because they didn't take into account the afterborn children. So they had a child a year before he died, and she was left out of the trust. And so because they didn't update and maintain it when they had the birth of the last child, they had to go to probate court. And also what ensued was, as most of you know, litigation happened with Kobe's mother and Kobe's wife regarding that. But that's what happens when you open up a can of worms in court. People come and challenge things because that's what court asks you to do. Does anybody object? So make sure you maintain the trust and update it when things change so that nobody has to go back to court for anything that you forgot. Wow. So we're going to open it up for Q&A if we have time. And I'm not for sure. I shared my screen so nobody sees the screen.
We can see it.
Yeah, we see it.
Yeah.
For a while, it wasn't moving to the new slides.
Okay. So we'll open it up for some questions then, if anybody else has any more.
I have a whole list here.
Oh, okay. Well, you might want to save that for 101 then.
Oh, no, not for me personally, from people who sent it in.
Okay.
Unless, and let me see if anybody has put any in the comments. There's none there now. All right,
I'll ask one.
Yes,
one.
Go ahead.
All right. Should a wife or a husband suppose a wife or a husband make a will? Should his spouse or her spouse see that will before death? Before he dies or she dies? Should they be able to see it, or should that person keep it private?
If you have a good relationship, you do it at the same time. So you know that you're giving assets to each other. Now, if a person's not willing to show you that, then there's nothing I can do about that or anybody. I mean, it's for whatever reason. And generally that happens in remarriages sometimes. But yes, most married couples in a good marriage, they generally do it at the same time, or they give them a copy. If you
Okay.
don't have a copy or the person won't show you, then that's
Something
obviously
is
not a
wrong.
good situation.
True.
Okay. But that should
Got that.
prevent you from doing your own individual plan. You don't need your spouse's permission for that.
Right.
Because
Right.
obviously you're not trying to give your assets to that person that is not willing to show you who they're
Right.
giving the assets to at death.
Right.
Mhm.
One other question I had sent in was that she said, my daughter has been telling me to do this and to get a lady bird deed. And I had somebody else mention that. Do you know what that is? And
Yeah, ladybird deeds are in a few states. So don't think that this is in every state. It allows you to file and record a deed as to who's going to get that particular property after your death to bypass probate. That's a plus. The negative side of that is some people don't record it correctly because it's a unique deed. Some people don't update it and the wrong person gets the property because they forgot they did it. Some people think that the ladybird deed will automatically give the property to the person protected, which it does not. And you can't do it for minors either. And you can't do it for any disabled beneficiaries. So you really need to get some advice. We do those too. And so it just has to make sure that you understand the pluses and the minuses of the ladybird deeds. Okay.
okay. Did you have any more, Colleen?
Not really. There's something that I didn't hear, and I was wondering what it was. I saw it somewhere. Transfer of debt designation.
Well, that's a ladybird deed, same thing. Transfer on death, you do the same thing.
Which one supersedes the other?
It doesn't. They're very identical. It's just the way each state that has it words it.
Oh,
Now,
okay.
you could designate beneficiaries on accounts and life insurance, and that bypasses probate. But again, you can't name minors or disabled beneficiaries because that'll just end up in probate court. And when you designate a beneficiary instead of your trust, they don't get any of the protections that you may have put in your trust so that your children doesn't lose it to their divorces or lawsuits or creditors. It doesn't prevent, if you're giving everything to the spouse remarrying, which, by the way, men remarry generally, women do not at a later age. And then the new spouse gets everything and your children don't get anything. So you can't do that you can't protect against that from beneficiary designations or ladybird deeds or transfer on death deeds. You have to use a trust for that purpose.
Okay, so we talked a lot about spouses, but I had a couple questions about children. When children die before, say, the parents.
Well, you have to decide if you were intending to give that deceased child anything, you want it to go to his or her children instead of going to your other child. So those are the things that you have to plan for when you do your trust.
So am I to understand that you guys are recommending, that might not be the right word, the trust over a will?
Oh, absolutely.
Definitely, yeah.
We make no qualms about that. Now, it's just way cheaper than probate. But if there's a cost factor, then just do a payment plan. Yeah, it's going to come out of your estate either way. You're either going to pay a whole lot in probate court, or you make a little bit of a budget and get your trust done to make sure that a big chunk of your assets are not going to be wiped out in the end.
You mentioned a couple of times, well, more than a couple, about disabled children. I had a question where the person said that She has two nephews in their 20s. One has a disability, and the mom did everything before she passed last Christmas. She had life insurance on them since they were kids, but she's listed as a policy owner. How do you work on a transfer of policy ownership and avoid probate?
Well, I don't know who's the owner currently.
The person who died, the mom.
Well, then the death benefit should have poured out then, because usually the owner is the insured.
Okay.
So who's the beneficiary?
Attorney Holly, I think she was asking about when the mother had bought policies where the children were the insured, but
right.
she was the owner.
Oh,
so
yeah, you have to go to probate court.
You have to go to
change
probate if she's already passed.
Okay.
Yeah,
What she
you have
could
to
have
go to
done,
probate court to change the ownership.
what she could have done before death, if she was still alive, was put a contingent owner on those kind of policies, so that upon her death, the ownership automatically transfers to whoever she named as the contingent owner on that policy.
Okay, so that would be your recommendation. Like if I had a disabled child and obviously I'm older, I would put a contingent plan.
No.
Not for disabled.
For disabled children, you should either change the name of the policy owner to the trust, but certainly put the beneficiary, because the owner is different than the beneficiary.
Okay.
The beneficiary needs to be the trust so that the child can receive it protected and also be eligible for government benefits.
Okay. I hope they're listening.
I hope so too.
My last question, just to double check on it. Maybe I've said it already, but can a person who has a living trustee, who is a living trustee, so to speak, inherit the dead person's debts?
Yes, they can be the same person. The trustee can be a beneficiary. The
But
successor trustee.
Would the person inherit the dead person's debts?
Well,
All the debts that
the way to look at it is the debt follows the assets, not the person. So the debt, whatever assets the person had, it follows that. Now, HJ made it very clear, if you're in probate court, you're going to have to pay that in full.
Full, yes, before.
If you have a trust, then you can work it out.
Okay. So it works out before. Okay.
Yeah.
One last question on my list was about Medicaid. If your loved one was on Medicaid, the state will come back after any monies that they feel that they're owed?
Correct. People, brag about being on Medicaid. They tell their friends, here's how you do it. Hospitals, nursing homes will fill out the application, but it's not their job to tell you that your assets are going to be used as reimbursement. Okay. And because the hospitals and the nursing home just want to get paid. So they're more than happy to fill out that application for you. But the Medicaid does seek an estate recovery from that. Now, there is an irrevocable trust that especially a lot of seniors will use while they're competent, that they put their home and other assets in there, but primarily the home. And in the event that they ever need Medicaid in the future, they don't have to give up the house as reimbursement. It'll be protected. But the trust has to exist for 5 years. It doesn't work from a Medicaid standpoint where they can't get to that asset unless that home has been in that trust for 5 years before they get on Medicaid. Now, some people may be already on Medicaid owning a home, and each state has different rules as to how they're going to do an estate recovery from that home. And in some states, we can still do the trust because they only do recovery in probate court. So if you never have to go to probate court and you have a trust, then they don't take that house. So you need to really get advice if you're already on Medicaid or you know somebody or your parents are and they own a home. You better get some advice from us as to how to save that home to give it to the children. Because not doing anything means that the children will not be getting that home.
Wow.
Those are all the questions I had. You answered some along the way, so I didn't need to ask them.
Okay. All right.
All right.
Well, thank you, everyone. This was wonderful, and it's amazing that you're doing this for your community. And again, it's the women that are generally having to deal with these issues. So
That's true.
this is very important information that you're sharing with your audience and your community, and hopefully with or without the participation of their spouse or their partner, you can still do your own plan to make sure that things are smooth upon your passing or mental incompetencies issues.
Yeah.
Right. Definitely.
Well, thank you so much, Holly and Yeji. Thank you. Thank you. This was eye-opening in many respects.
Very informative. Yes.
Yes. Thank you so much. We have a comment. Oh, this lady, Carlene, says, thank you so much, attorneys Jadis and Yoon. This was great. It was. And we are truly blessed. And we will share. We usually repackage and reshare several times. So it will be up. And this is a QR code that people can scan, right?
Yes.
Right. So if you're interested in a consultation with the attorneys, just scan this code. Make sure to tell them that you were watching Daughters of Sheba Foundation. And this is where you got the code from, so that you can have first, is it half an hour? Is it 15 minutes?
I know usually it's an hour.
Okay. You have
That's good.
It just depends on how many questions you have.
Okay. Well, thank you so much, attorneys. Thank you.
Thank you.
Yes, thank you very much. Thank
And
you.
thank you, everyone, for
Bye.
joining us. We hope you found it informative and
Was.
useful. All right. Have a good night, everybody.
Good
Thank
night.
you.
Thank you.
Bye-bye.
Bye.